Thank you. I think it will be very useful to know the background you had mentioned earlier also in brief. I am sure I must be knowing some of you, and Madam gave a very kind introduction of me, but I would like to add one thing that the syllabus of the Bar Council of India, the model syllabus that many of you must have seen, for the subject of law, language, communication in English was designed by me. And today the topic has something to do, you have the topic in front of you. It has to do something with decolonization, with law, language, literature, and communication, and also Indian knowledge system. The biggest challenge that I face today is that we have just around 1 hour with us, or I think we cannot stretch it beyond 1.5 hours. But the topic is so significant, it really requires a couple of days. So let me start from the point that comes to my mind first, maybe what it is. Many of you do not know. Many of you are teachers of other subjects. Mostly it appears you are from humanities, but some of you may be from the field of law also. And many of us are from the field of English, literature, language, etc. It's popularly known as English. Although I think in a law school, we do much more than English. It is rather a curriculum of humanities, and it covers these major broad areas, which are language, language like English, the regional language many a times, literature, and communication. What is the significance of this field? I think this is one of the most significant fields or one of the most significant subjects. I am not belittling other subjects, but we have to, as teachers of English or as colleagues of people who are teaching this subject, realize the significance, because many a time it is undermined, it is underlooked, and people think that it is just a passing subject, it's an additional subject, it's a necessary evil. I think if I ask you to raise your hands, many will not raise the hands due to political correctness. But I think that is the impression that we get in professional courses, and law is not an exception to that. But in law universities, humanities and especially literature has a very central role, because law as a subject belongs to the field of humanities. As we know that in the beginning, knowledge arose in the form of philosophy, at least in the Western traditions, and then it was subclassified, divided into different fields like natural history or natural philosophy, and law was also one such thing. At the time of bifurcation between humanities and social sciences, and also within humanities, there are origins and seeds of literature, and it was explicitly so. If you look at the works of Cicero, Proarchia specifically comes to my mind. Is it okay if I ask you how many of you are aware of Proarchia? Proarchia is a defense speech which was delivered around 2500 years ago in the ancient Roman court by a very celebrated lawyer known as Cicero. It was in defense of his teacher, Archias. So does it ring a bell to anyone? Please raise your hand, feel free. We are colleagues and we should be talking. It is not a lecture. I am not delivering a lecture. I am talking to you. You also please talk and contribute. So it appears that no one is aware of it here, but that's something very interesting, and people in political science, in literature and law, I welcome them to introduce it in their curricula, in their classes, because of the great significance of this. Cicero was a politician, he was an advocate, and he was, of course, his admission, self-admission is that he was someone who loved literature, who was trained into literature, and that is something from where his law derived, his legal practice derived. the word he uses is oratory. So in those days, oratory was one of the most important things in a legal forum. And now also it is important, but still, I don't think it is acknowledged as such. So in those days when there were no law schools, no universities of law, no colleges of law. So Cicero, do you think had a degree of LLB? I don't think even the degree was invented. It was not invented as a matter of fact. And how people used to become lawyers. So there were two qualifications required for that. One was people who could speak very well, who could defend others, who could represent others, who were orators. And the second thing was that who had an idea of the human condition and also of the laws. The laws were mostly unwritten in those days. Now we have codified and written laws predominantly. But in those days, the laws were in the form of songs, in the form of oral traditions, in the form of precedents primarily. And the word of the king was literally the law. I think many of us are aware of this concept. So in a particular defense speech, in defense of his teacher Archias, he spends a lot of time in defending literature. And why he defends literature, I will give you a background of that. Because Archias was a poet, a very interesting thing. He was from Syria, which is known as Middle East by the people in the Western Hemisphere. And for us in India, it is West Asia. Many of you must have heard the name of this country, might have visited, might have known it. So he was a Syrian poet, but because of the Roman Empire, he went to Rome, and he was a tutor to Cicero, and he was also a famous poet. That was his credentials. And Cicero was defending him on a matter of citizenship, which sounds very, very contemporary. Like even now we have these matters of citizenship, especially we hear it in the context of, for example, USA and other rich countries. But now it is becoming important in our country also. There are a lot of controversies, a lot of politics about it. All those things are there, but this jurisprudence is nothing new. And I am still in the field of literature when I am talking about these things. So he defends his teacher, one, because he was a teacher, second, for political reasons, and third, professionally, because he was an advocate. But the professional angle we can put on the back burner. Why? Because I don't think he was charging any money from uh, Archias. So what he does is that he was such an accomplished advocate that he uses only a few paragraphs in defending his teacher legally and technically, but rest of the time he spends in the defense of literature. Why literature is important for an advocate? He says in that he could be an orator or a legal speaker because he had a background in literature, and that background came from Archias, the teacher, who was solely ensconced in the field of literature. He had nothing to do with law. And how literature can be important is important for an advocate. So I think that's a very, very wonderful and good introduction to the interface of literature and law. That is one thing. Secondly, we are dealing with human beings everywhere. As teachers, we have to deal with human beings. We have to realize it. And we have to make them realize that primarily they are human beings. It is not that they are just going to be some sort of technocrats or some sort of automata machines, or they are going to be just mechanical beings. Somehow, it appears to me that most of the technical programs are by default, I am not saying by design, maybe by default unintentionally, possibly, expect to create people who are technologically sound. But in the whole process, the education itself suffers. What is education? I think education is polishing the human being, uplifting the human being, or extracting the best out of them, the human element, whatever it is. This human element can be debated, we can discuss it to no end. So, in a law school or in an engineering school or a medical school, the only scope for this exploration in an explicit way comes from a program in humanities, in a program in literature. Typically, in a law school, the English teacher is assigned the task of dealing with humanities, and other subjects are exclusively either social sciences or law, inverted commas. So I would say inverted commas, law subjects. Social sciences are political science, sociology, economics. So a typical law school structure is that you have social sciences and one paper in humanities, and that is always under fire. I think it is very hard for some people to stomach that English is being taught and literature is being taught, humanities is being taught to students of law. That is why this opportunity is something which is unique and great, that we are talking about literature, we are talking about humanities in a law school and in technical programs. So one of the important things all of you might have experienced is that the students in general face a lot of stress these days. I think this is much more, exponentially more than what we used to face a generation ago or 2 generations ago, although the things were not easier at that time. Let us analyze, and I will ask you to contribute at this point your own experiences. What do you think is the cause of an increased stress now, especially in a professional program? So I wait for a moment while you raise your hands, or you can even type your responses here.
Inability to understand the human condition.
Yes, wonderful. Inability to understand human condition. Anyone else, please?
Sir, cutthroat competition and unrealistic expectations from students.
Yes. So they are expected to be like robots, just knowing the subject, just knowing, for example, mechanical engineering, electrical engineering, AI, in our case, knowing the laws, the constitution, the acts, the sections, the articles, right? They are valued basically, their value depends basically in terms of money, in terms of employability on these skills somehow. And what is the outcome? The unbearable amount of stress, and we see, I won't get into the details of it, but yes, madam, Madhumanti ji.
So sorry to interrupt. I would also like to add another reason for the stress that you mentioned, that there is a lack of understanding of our basic constitutional position, that we are uh, connected to many other things other than the materialistic goals that we are learned, we are taught to pursue. For example, our very natural environment, many human values. So these things are so very missing in the technical education and the materialistic pursuits and the goal-based kind of a teaching that is happening. So that is my input.
Wonderful. And I would really appreciate if like you tell about your background, like which subjects you teach or where you teach.
Yeah, sure, sir.
All
So
of you, please feel free.
Sir, I stay in Mumbai. I teach at a college under Mumbai University, and it is not a professional course. It's a degree college where I teach year, first year to MA. We do have an MA course also.
And what is your subject?
English
English.
literature.
We
Yeah,
don't, everyone is not from the background of English here.
right.
Okay,
And
but
my
that's really
PhD is
wonderful.
also in the same field. Yeah, in ego criticism and poetry.
Okay. And I am really pleased that you have mentioned the Constitution. I think it is a very big humanitarian, humanistic document, and people just think about the articles, just about the so-called legal provisions, but you have directive principles there. You have fundamental rights and duties there. So there, all these things which Madam just mentioned are there. For example, about the environment, about the human dignity. Even in the preamble, there is a hint of all these things. So certainly, so people are not aware of these intentions of the Constitution. That is one thing. And secondly, this humanistic approach is lacking somewhere. So most of the programs just take literature as a means of getting some marks. As I said initially, a necessary evil. Sorry to use such a word, but that is happening. And if you look at the whole academic environment of the country and maybe globally, we are moving towards so-called technical or practical courses, professional and technical courses, because I think this way one can become employable very easily. And the scope of traditional literature, language, and humanities programs is really shrinking. So I think many of you may agree with me on this point. So this is the situation, and what humanities helps us in doing, helps a student in doing. First of all, realizing that they are the human being. And secondly, realizing that the whole world is actually human-centric, and we are going to be successful, or we can survive, or we can be well balanced only if we are able to connect with people, if we are able to realize that law is for people, engineering is for people ultimately. And one example comes to my mind. For example, this iPhone company. I am not advertising for any company, but their logo has been this, that it is for the people, looking about or thinking more about the user. I think technologically it is great, certainly, and many other brands must also be, but that is what their claim is. And the success of this brand, all of us know. I think it is undisputed. So without asserting that it is human-centric, although I am a user of iPhone, but I won't give my views. That is the self-assertion of this company, that we make things which are people-friendly, and the success. I think that proves a point here. Likewise, the stress levels are there because I think somewhere the education of self, of the well-rounded personality is missing. That is required. And what can give that? Not just a professional or technical program. They are very, very useful. Of course, they are the engines of our progress. They are the things that run the society in a very big way. I am not discounting them. But what about the human being, the student as a human being? First of all, we have to focus on them as human beings, and where it will come from these programs that we are talking about today. The focus must be there also. And also we have to realize that the clients we are dealing with, for example, the clients of a lawyer, they are also human beings. They have to understand and they have to be able to connect with the human situation. They have to understand the human mind, the human heart, the human condition, and how the human beings behave. And only then one can be a successful lawyer. I think that is the introduction, the interrelationship between law and literature. So I welcome all of you to say a few words, And by the end of this session, I think there are around 70 people. Everyone should be contributing something. Let me take a sip of water while I wait for you. And I go to the next thought. Okay, great. So coming to the second aspect, law and language. I would like to come back to law and literature if time permits, or maybe in the second session that I have some other day. Today, briefly, I will talk about law and language also. Law and language are inseparable. Inseparable to the extent that one author has said that law is language. Now it sounds very shocking, even contradictory to what we believe, that law is a very separate thing and how it can have anything to do with language. Is there anyone who would like to contradict this statement? It can be easily contradicted also. That law is language. That is the statement. That is the assertion. Do you think it makes some sense? There are some similarities between law and language. One of them is that it is structured. Both of them are structured. They are rule governed. All right. What else? Anything else?
Sir, just to add in here,
Yeah.
according to me, language comes first before even the existence of law. So
Yes.
these are the two disciplines which are indispensable, inseparable. They're like two sides of the coin. So for me, if there is no language, no law exists. So hence, and we know that I'm not from a core law, but law is all about a game of words and about manipulation of words. I mean, some people participants might not agree. So that's what I believe. It's the power of language. So language comes first, even before the existence of law. That's the essence of law and language.
I will support your statement, and I would even go to the extent of saying that language precedes even being a human being. Well, let me rephrase it. See, most of us believe in science, and we believe that we evolved from primates, right? It's a belief system. I am not imposing anything. So during our evolution, it is believed that we became human beings, or we are human because we have a language. Language is unique to the human beings. It is a very specialized communication system. All beings communicate, including plants. All communicate, even bacteria communicate. The primates, the mammals, the birds, the amphibians, they all communicate. But the specialized system we have, it's so specialized that maybe if we question ourselves what makes us human, most of us will, I think, come to terms with the thought that we are humans because we can think. So it is believed that thinking can also take place only in language. So I give you a moment to sink in this thought. To some of you, it may be sort of difficult to believe, but I am sure that most of you might have come across such a thought. You are
May I?
free again to say what you want. Mr. Mrudul, yeah.
Yes, sir. So, sir, I just want to add something.
Yes, yes.
Let me introduce myself. I'm Mridul Shanai. I'm a professor at BIT School of Law, Chennai, and I teach international law, then interpretation of statutes, then procedural laws like CPC, CRPC, etc. So, sir, I would like to talk about customary practices which evolved without the help of languages, especially international law is actually governed by laws of nations, how they interacted with each other. Even with absence of language to communicate, they entered into practices solely because they had a consciousness as to how to enter into contracts. Then concepts like pacta sunt servanda. that promises must be kept or agreements must be kept. All these things evolved from a consciousness rather than language.
So you think it was like instinctive behavior, like when two dogs meet, they will wag
Yes, sir.
a tail?
Yes, sir. So the
It was
social contract
instinctive.
theory actually supports this particular aspect. Sir,
Well,
it's my
thank
just
you very much. I
sir.
appreciate your contribution.
Yes,
See,
sir.
basically, I introduced another thought that thinking is possible in human beings in language. And I do not think that this international trade or whatever legal behavior we have, that is just instinctive. It is based on thoughts, thinking. And in anthropology, there are concepts that people do not use words sometimes in barter system, and they keep the thing somewhere and another person takes it and leaves something as there. So some people from the background of anthropology will know that. So maybe that is the beginning of trade, but look at the sophisticated level of thinking in that. That is a mechanism to avoid conflict. Like in trading, you give something, take something. There is something more than just a neutral exchange. It has some other value also. I won't get into deeper aspects of it, although I would have loved to. So I think language is involved before any law. Any law means human laws, positive laws, right? Divine law, obviously, that's another thing. Laws of nature are another aspect. That is something different. But in case of animals, it is different. Like it is believed, it is the mainstream thinking, human thinking, scientific thinking, that animals do not have language and hence they are not also able to think. Like two dogs, they are sophisticated animals, they feel and they have evolved behavior, but there are many things they can't do. For example, can your dog or your cat or your any other animal, sorry, there is a failure of electric supply. So do you think they can communicate something like there is a party tomorrow in Shillong? I am sitting in NCR. I am in Gurgaon at the moment. So I can communicate with you very easily that tomorrow Merelin has arranged a party and I am going to attend it. That's very much possible, right? But do you think two dogs can communicate such things to each other? Their communication is basically here and now. And secondly, it is not something that goes to the level of thinking. Now, this is slightly controversial and philosophical, and it is something we can debate about. Even we can think of very few things without language. For example, we can think of the path to our homes, way to our homes, from our office or within the campus, different rooms. You can close your eyes and do this small experiment that what all you can think about. I think we should do this experiment. Should I give you 30 seconds or 1 minute or 30 minutes, whatever you like? Let us start with 30 seconds. Close your eyes and try to avoid all language and think of anything, including what you are thinking. Should we start it?
Um, Hello, sir. Before we start with that, I just want to
Okay,
say
okay.
one thing.
Yeah,
Hello,
yeah,
my name
welcome,
is
madam.
Deeksha. So since you gave an example of the dogs, I was just wondering maybe they do have a way of communicating complex thoughts to each other. We just
Yeah,
won't
yeah. Sorry,
know of
let me
that.
interrupt you at this
Uh,
point. Sorry.
yeah.
See, I told you earlier also, all animals, including plants. I think many of you will not agree that plants can communicate. They all communicate. Yes, please continue.
And another thing, I mean, then how do we save ourselves from bordering on having an anthropocentric view if we are talking about humans being at the center of this whole idea of language and communications then?
See, I avoided this anthropocentric view by saying that all of us have communication. We communicate, but human beings have a very specialized communication system. And I gave two examples of it, like the animals can communicate only here and now, right? And they cannot, for example, if a dog barks, it can mean danger here, or it can welcome someone. right? But it is here and now. It is not across time and space. So our language can take us around that. There are design features of language. So there are around 14 design features. I can mention a few to them. For example, we can almost infinitely communicate things. Why? Because we have infinite symbols. The maximum symbols that an animal was found to have was vervet monkeys. They have around 105 symbols, sound symbols of communicating, right? But how many symbols we have? Infinite, simply infinite. Welcome, madam. But this is such a wonderful topic you have raised. Thank you for that. So how many we have? Infinite. And why do we have infinite sound symbols? Words are sound symbols with associated meanings or approximate meanings, changing meanings, dynamic meanings. Words are bundles of meaning. And this bundle has arbitrariness. In animal communication, arbitrariness is not there. Like woof, woof can mean only one thing for all dogs. But for us, I think if I say, uh, like in Assam, if you say rabo, robo, it means stop. But if you go to Punjab, people will misunderstand it for God because the word is like rab, rabba, robo, fine. So the same word can mean many, many things. And the list is not limited to languages. We can in this group decide that let me call it kal, for example, this pen. Just call it kal or anything, any other word, kak. It is arbitrary, but it is this faculty or this facility is not possible for animals, that they can agree upon meanings and they can assign arbitrary meaning. Another feature, and I think the last one I will mention is um, that we can have structure within sounds. For example, we have 26, 28, 50 sounds in different languages. Some languages can even have more sounds. And these sounds can be rearranged, like the word pen. If I rearrange the sounds, I can make it nep, N-E-P, P-E-N. But for animals, woof cannot be cut into smaller pieces like woo, 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 fur. They can't say foof. They can't rearrange it. So that is the reason that linguists believe that language is unique to human beings. But communication is not unique to human beings. Communication is something which is fundamental, primary to all existence, according to me. Although linguists may stop at bacteria, they may not agree that bacteria also can communicate. But if you are from the field of zoology, you would realize that yes, they communicate, right? So coming back, so it is a very fundamental feature of us being humans. Secondly, law is like the scholar I quoted, law is language. But even if I don't make it so controversial, I would say that law has a lot to do with language, maybe more than anything else. One of the reasons I would say is that, sorry, I don't know where my phone has gone, no problem. So one of the reasons is that all law is spoken or written in language. Is there law which is beyond language in any form? Please tell me, please enlighten me. All the questions you have raised have really made me think a bit, and I would appreciate if you give me more perspectives. I have made an assertion that all law, whether it is oral tradition or it is in written tradition, is it written or not written? Has it got something to do with language or not? Yes, madam.
Sir, even before we get into the relationship between language and law, of course, they are related. But law is also like language, it is also a discourse. So
It
there
is
can,
discourse, yes.
yeah. So there can be many forms of that discourse. There can be
I-
many different discourses. There can be many different laws in the same way. So just as there are many discourses in language, and some kind of a, even before language comes, some kind of a thought. I would say thought precedes that language. So a thought has definitely gone, which has formed the discourse, and then that discourse was expressed in language. So
Yeah,
that
instead
could
of
be a
thought, I think in the paradigm that we are exploring, we would say a concept is there.
concept, correct?
Yeah. Because I have already said that thought is not possible without language.
Right, right. I think so. You were referring to Saussure's mental image and the sound image before language. So
Yeah.
the same kind
Concept.
of thing. Yeah,
Certainly.
yeah.
So from the concept, we arrive at language, and there are symbols with which we associate these thoughts. So coding, decoding, all those processes are there. I think you know a bit about it because of your exposure to linguistics. So that is fine. So law is associated with language. We were trying to explore that. Can you please remind me where we were at which point? Mm, well, first is that all law is in the form of language. It is encoded in language. As madam said, it's a discourse. And I would add another thing, that there are registers, like we have a legal register. So at all, there can be legal dialects. There are legal languages, like you have the legal jargon, legalese. These are all very potent and very vast and profound fields which require a lot of work to change the human condition, and they affect us. For example, let me just talk a bit about legalese. I am feeling like, you might have heard that story. A king gave the offer to a person he was pleased with to measure all the earth, all the ground with his feet before sunset as he could. And this man just ran here, there, in all directions. But the sad story is ultimately he fell dead by the sunset. So he measured, he traveled and covered a big piece. So I am also like that. I am seeing that the time is approaching completion. So I want to touch upon a lot of things, but still. So one of the things we were talking about just now was the legalese. Legalese is a wonderful thing. It is a register. It is a collection of words, terms, concepts, which are specialized and which is used by the lawyers. It is used by the lawyers to communicate complex thoughts in succinct ways within their own communities. That is fine. So this is a wonderful thing. But at the same time, it is abused. And some authors have written that this abuse is intentional. And how it is intentional? The intentionality is it is suspected that some lawyers do not want others to understand. And if people understand what they are saying, then they will not be able to justify the big fees they charge. This is a very fundamental entry into this field of legalese. But what do you think about legalese? Legalese is a special language which sometimes even judges say we are not able to understand what the advocates are talking about. It is such a complex thing. It is also known as legal jargon. So what do you think about this? This is good or bad? Or how it can be bad? Anyone?
Sir, it goes against the very concept of justice, I would say.
Yes. But how? It goes.
Yeah, because it goes against ethics. You can deceive people.
One
So this
aspect is deceiving. I see another hand, that is Ms. Lamba. Yes, madam.
So, as far as legalese are concerned, I mean, even when we teach students. To give you a context, sir, I am a student and a professor of English literature, but I am teaching a batch of law students. I teach in a law college in Mumbai, and the whole concept of legalese, because they also have a subject that's called legal language in their curriculum. So the whole idea is that legalese do exist, but until and unless we don't understand it ourselves from the very core or foundational aspect, right? And when we organize certain competitions or internal level events for the students, and there's something that's called client counseling. So the first objective of teaching the students something like that is that they have to ensure that they are not engaging in legalese while they're interacting with their clients. They have to maintain a certain amount of transparency, irrespective. While you rightly pointed out that they have to justify their big sums that they're going to charge their clients, but they need to have that ethical aspect of being an advocate, where they cannot really interact with their clients one on one. They may use those legalese in their courtroom, but when it comes to their client, they have to be as transparent as possible. That is the first and foremost core aspect of their ethics as advocates.
So wonderful, wonderful. Thanks. So let me add another perspective to this. See, if we look at it from the perspective of consumer rights, who is the consumer, ultimate consumer of laws or law, legal system, the enforcement, all the aspects of it? The litigant. They are the ultimate consumers. And if they are kept out by a language that they don't understand, where the matters of their life and death are being discussed, decided, settled, then do you think it is justice? It is injustice. And secondly, they won't be able to speak up for themselves because they don't understand what's going on. People are discussing about their life and death. So that is one aspect. So that is why the first aspect I mentioned was that legalese is a beautiful thing, or legal language is a beautiful thing, because it succinctly records, it succinctly expresses the fine and sophisticated thoughts of the field. That is fine. But when we are communicating with the masses, and most of the people who are consumers of law are the lay persons. They are not advocates, they are not the judges, they are not the members of the legislatures. So then we should use language which is simple, which people should understand. Otherwise, the whole purpose is defeated. So this has to be considered very carefully. And again, to sum up, again, summing up may take 10 minutes. So don't be so hopeful, please. I would like to just show, Madam mentioned the word client counseling. Client counseling is when an advocate meets the client for the first time. They have to understand what the problem is that they have, the legal problem. They have to explain also what are the rights, what are the possibilities, and what are the liabilities they face legally. So this is to be communicated. This is to be done in language, number one. Number two, it should be done in a language which the client understands. If you use such big, frightening terms, then I don't even think it is ethical, because that way you are just confusing and frightening the client. The second stage is when you draft legal documents, including contracts, including the petitions and other things. So that is drafting. That is done in language. So I will be talking about all aspects of law, and we will also keep the house open for your suggestions. If there is anything in law from ab initio, this is the first point where you are meeting the client. Is there any point where language is not used? A law is happening or is taking place or is being conducted without language? And I presume, and I believe at this point to begin with, that it is not possible. In the courtroom, what happens? Oral language is used. The discussions take place, the arguments, examination in chief, cross-examination, everything takes place in language. Then we can go to the next level, that of the judge. They pronounce judgments in language. Let us go to a level still higher, that of the legislature. the parliaments, they debate different aspects of a law before the bills are turned into acts. And how it happens? It happens in language. And how these acts are written? They are written in language. And language is so important that I remember someone has said, some famous advocate has said, that in legal battles, we fight primarily about the commas. And that is a fact. What they are discussing in the courtrooms is very, very primarily or very importantly is about language. What is the meaning and intent? Like someone was talking about the interpretation of laws. So what is the meaning and intent of the law? And can it mean different things also? So that is the importance of language. And that is why our students should really know the language. By language, I do not mean only English. I mean the language of the court. And in different countries, in different states of India, there are so many courts, the language is different. That also brings us to the concept of translation. See, in the Supreme Court of India, English is used, and how many people, how many of us speak English in this country? I think it is a very small minority. And when it comes to such serious matters of life and death, do you think we can deal with a language which we hardly understand? Many of us, including graduates in English literature, don't understand English that well, and many of them are not even able to speak it. We all know that, right? So do you think that justice can be done this way? So one of the ways out is, since we have a lot of plurality in terms of language in this country and we celebrate it. Our country is a very special type of country because I am not able to think of any other country which has the states based upon language. We have linguistic states, and language is connected so intricately with culture that this is a good way of making cultural states also, that the states have similar ways of life, similar perspectives, etc. So in this country, plurality should be celebrated. It is not, I am not even talking about accepted. I am just talking directly about celebrating it. And when it is required, so what should we do? One of the practical ways is translation. But I think we are lagging behind in a major way in translating in the courtrooms. I think the last case that we remember was of Ajmal Kasab, who demanded translation. And I think the basic purpose of that translation was to extend, to delay the proceedings. That was the only thing, because I think generally he would have understood the language of this country, the language in which that was I take back my words actually, because when I am thinking, I realize I am just quoting the debates in the newspapers. But anyway, so the last time we saw translation being used was and provided was in the case of Ajmal Kasab. There might have been some other cases, but they are rare and few. So I think it should become a norm. So with this, I think I can give a pause because Madam asked me to stop around 8 so that there is some time for discussion, although we had a lot of discussion already.
So you can, if you still have more points, you may. Otherwise, we can take queries from the audience, no doubt.
Well, as I said, I realized when I started this talk that we should really keep aside 1 week. So anyway, uh, coming back to law and literature, I am not touching upon communication today. Maybe in the next slot, I will try to do that. One thing we have to understand is that literature has its inherent value. We have to teach, that is fine. I am addressing all the teachers of literature in law schools. But one important responsibility we have is to connect this literature with the needs, perspectives, and situation of the students of law, both personally and professionally. But here, what I mean is primarily professionally. So it should not be that anything that we like as great literature, we should teach them. It should not be only random collections based upon our whims and fancies, upon our likes and dislikes, but we should go for the pieces that give us an opportunity to discuss law, to discuss jurisprudence, where the students are able to look at law from a different perspective. I think the courses that we teach should be really literally an integral part of the law curriculum. They are, of course, officially they are, but there appears to be a disconnect. Why this is so? One of the reasons, according to me, is this. Will someone like to say or comment something about this? I have some examples of the type of literary pieces that can be covered. For example, there is a poem, Slave Auction, by Francis Harper. This is about social justice, but it is very, very shocking. It is about the sale of young girls in a slave auction. It was written something like 150 years ago, about a century and a half ago. But still, it makes the students think and connect with the concept of justice. There are things like, there are two poems written by me, and in the legal circles, many people are reading them. One is Law, another one is Strength of Justice. The first poem, Law, makes one think about the nature of law, its existence, its prevalence. The second one is about why people commit offenses in the first place. Saki's background is there. It is about international law. It is about the conflict of law between human rights and copyright and intellectual property laws. There are pieces like Rabindranath Tagore's concept of education. I think that is something which applies to all fields of education, because it is very, very important that students at this stage in a law school should think about educating themselves. Primarily, one has to educate themselves. We educate ourselves. It is not possible that someone lectures us and we become educated. So this is a collaborative, cooperative process, active process, and primarily it is learner based. That is my belief, and this is the belief of many others. I just follow this line of thought. So that is also about Indian knowledge system. We have to incorporate consciously the beliefs, practices, time-tested practices of the Indian system of knowledge generation, knowledge transmission, and the meaning of knowledge itself. What is knowledge? All these three things are different in different cultures. India is considered a linguistic area. By linguistic area, what we mean is that all our languages belonging to four major different families share a lot of, this is Grierson's view, a colonial scholar who studied Indian languages. So according to him also, or to any scholar who even superficially studies Indian languages, this will become evident that we have a lot of commonality. And why I'm talking about it all of a sudden? Because I have just touched upon the concept that language and culture are connected. So India is also a cultural area by extension. We have the concept of right and wrong, similar concepts or some commonalities there, ways of life, it is there. So the literature that we study should reflect. For example, if you look at the Tamil literature, which is one of the oldest literatures in the world, the Sanskrit traditions, which are also pretty ancient. In Tamil literature, if you can include this story, Sitapati Karam, is there anyone from Tamil Nadu or who has heard about this story? So this can be used in a law school. It can teach us about the concept of justice. Concept of justice is very important. I think the concept of justice is lacking in most of the formal law courses. So this responsibility lies on our shoulders. I would say this big responsibility lies on our frail shoulders. Or maybe, may I modify it a bit further? This heavy responsibility lies on the frail shoulders of English teachers in law schools. Why frail shoulders? Because we are fewer in number and many a time not as appreciated by the students and by the system as we deserve. By appreciation, I do not mean that we should be garlanded every day we enter the university gates. What I mean is that the importance of the subject is not realized that much. And then I am not blaming only the students and I'm not blaming the students at all, but partially two parties are responsible for it. One is we ourselves, because we fail to communicate the significance of our subject, of the subject we are teaching, the subject we are interested with. And the second party is the receptiveness of certain institutions towards the significance, importance, and the central place that humanities and literature occupy. So, any other views? I think I can stop at this point if you like, although the list is very
Yes.
long and yeah.
Uh, we will quickly get, a few questions we have in the chat box. So we have 15 minutes left. So can I read the question for you?
Welcome, madam.
Okay, so this is a question from Dr. Benjamin Darlong, who is an assistant professor at Government Degree College, Tripura itself. His question is, speaking as a teacher or a degree college, and with the coming of this NEP 2020 implemented in recent years, how do this interface of interdisciplinary subjects fits in Indian traditional knowledge perspective?
The NEP 2020 is talking in a very major way about interdisciplinarity, number one. Number two, I have delivered a few talks on that and even conducted a seminar on it. So I am happy this question was asked. And number two, it talks about the mother tongues, the Indian languages. So about the Indian languages, the whole tone perspective of NEP 2020 is to promote them, to preserve them. And some means have also been suggested. So when we juxtapose these two things, one is promotion of Indian languages and interdisciplinarity. So one thing very naturally comes. I gave you a very simple example, like Tagore can be included in the curricula of law schools. So likewise, the languages and the cultures associated with them, the values, the literatures of those languages can be incorporated. This is a very simple and brief answer that I can give.
Thank you, sir. We have next, can you suggest some more works in English literature, translations by Indian authors? Asked by Miss Joshita.
Okay, so maybe I asked the house to suggest a few. I have suggested Munshi Premchand is there for Hindi. We have Tagore, which I have already mentioned. Then in Tamil, we have Sitapati Karam and works like that. You can include, the list is infinite. One of the best ways can be, for example, if I ask everyone here, after giving a few examples, you can also ask your students. They will come up with typical law schools have students from across the country and across the world. They can also teach us. We should do a small survey and we should undertake research. I was planning to hold a session on research next time. Maybe we can do a research on this and make something publishable so that our colleagues can use it. We can use that research on which great Indian pieces of work can be incorporated into the syllabi of law schools and law courses. Yes, madam.
Thank you, sir. So I just have one from my end. Maybe you can take it a question or an observation that since we are talking today about law and language, the interconnection, um, when our Indian Constitution or state statutes are written in English, of course, and English is considered now a language of Supreme Court and as well as High Court, especially. So there are so many archaic words that we come across. And when a law professional, a lawyer draft or counsel the client, they are supposed to use the language which the client understand because as a client, I'm a non-literate of law. So, but then there are sometimes so much of jargon that legal jargons that we come across, it becomes difficult for the client to interpret and understand because I'm paying a lot. I'm coming to you to make me understand the legal terms or the legal procedures. So what is your thought or your idea on this, that should archaic words be continued using, or should we go for alternative trying to write in plain language? So when I say plain language, and I don't mean to delineate myself from not understanding much about the legal terms. So if you can throw some light on this,
Thank
because
you.
I'm teaching law and language too in the class. So
Yeah, I know. Thanks. So, madam, first of all, when you are saying archaic words, not only archaic words, legalese has a lot of such characteristics. Archaic words, big words, obscure words, foreign language words, etc., and words with different meanings than in ordinary language. Such usages and the constructions, which are very long, repetitive, doublets, triplets, all that is used, that forms legalese. So legalese, let us leave it alone. It has its own use. But at the same time, you are asking my views, and I'm finding it difficult to be original because many people have thought about it. And many countries have adopted plain language legislation also, including the US, Canada, Australia, if I'm right. And we need such legislation. According to them, you have to produce, for example, an act with translation into plain language. And plain language is not only about plain English, it can be plain Hindi also, plain Tamil also, plain Marathi also, plain Khasi also. So it can be plain means when you are not using, and this is also something associated with decolonizing the knowledge system. How? Because what we are following is we are blindly following the colonial traditions, colonial coinages, colonial words, colonial usages, colonial practices. So we have to think again, what our people need, what we need, how do we use language. Decolonizing is not counter racism or counter colonialism. Colonialism is racism. I have little doubt about it. So we don't have to just say that we are not going to use a particular language or English because it belongs to a particular group. We should use, but we should use whatever is useful for us. We should learn from across the world, like Ano, Kritavo, Santu, this most of us must have heard of. Let good thoughts come from all directions, all dimensions. So we don't have to fight English or any language, but we have to incorporate what we have, what our legal concepts are, what our literatures are, what our great scholars have thought about, what our traditions are. So I think that should suffice.
Thank you, sir. Thank you so much. Do we have more questions or queries from the participants? If so, we can still put up your concerns.
Sir, may I?
Yes, sir.
Yes, sir, please.
Shenoy,
Uh,
Dr.
sir,
Shenoy, yeah.
sir, on the concept of law and literature, sir, I've just a few observations that I've made when I gave assignments to the
One at a
students.
time, please, right?
Yes, sir.
So that I can respond. Yeah.
Okay. So, sir, I gave an assignment in jurisprudence class to adopt the concept of literature. And one student actually gave a very brilliant presentation on Dr. Faustus by Christopher Marlowe,
Mhm,
how he enters into a contract,
mhm.
and then what at the end of the day, what he actually neglects law, then all the sciences, and he wants more knowledge, and then he gets into the contract with the devil, and at the end of the day, he actually falls into this doom pit. So
Yeah,
basically, sir, at this point, I just wanted to inform the student as to the concept of hermeneutics. It's basically what interpretation of uh, that particular play with respect to the historical context in which that play was written. So will that actually play a very big role in interpretation of a text? That is what I wanted to understand.
yeah,
Because
certainly, certainly. I will give you a very simple example because most of us will understand Shakespeare's Merchant of Venice, right? That
yes,
is also about the same theme actually. So what
Yes.
we have read in our schools and even as in our universities as teachers of English, we have read, there has been one reading of it. The reading has been that Portia was a great lawyer and she was so intelligent, clever, or whatever. She subdued Shylock, who was a very bad and evil character. But we have to look at and deconstruct whole of it from human rights aspect, from the aspect of discrimination, from the aspect of even contract. How contract, for example, now in Indian Contract Act, it is there that what is a contract? The definition of contract is there is an offer, acceptance, and lawful consideration. This word lawful is generally missed by most of us, even professors of contract. Sometimes when they are talking, they may even, I have seen it, I have witnessed it. So where this word lawful could have come from? Maybe from Shakespeare. And there was forceful conversion. There is a total violation throughout the play, Merchant of Venice. Many will agree with me, I hope. So we have to look,
Yes, yes, sir.
yeah.
Yes,
It's a
and
beautiful text, Shrinoy, sir. You can I'm so sorry, sir, to cut you here because I really enjoy teaching Merchant of Venice in the class, and gives you a scope of how to interpret the loopholes can be in a contract. Portia, which cleverly shaded it, which no one could think of. That was the ultimate. I think the whole 360 degrees she turned, the whole case into a different level. So maybe you can exercise with your student as well. They'll enjoy this, and you may also read Shakespeare in the law. So this book is also like you'll get a lot of ideas about. No, now we are talking about decolonization. No, Shakespeare is coming in here. So, but yeah, it can
We
be
are not
interpreted
afraid
from
of
the Indian
Shakespeare.
perspective.
We are not afraid of Shakespeare, but bring Kalidas also in, bring Munshi Premchand also in. There are so
Right.
many authors
We have
in Marathi.
untouchable Mulraj Anand. There's also beautiful one. So
Ulak Raj Anand is there. Then in Marathi, this Silence the Court is in session that is there. So we
hmm.
can bring a lot of things from our literatures.
Right.
Mhm.
And even this Tagore's "Where the Mind Is Without Fear," it's like a prophecy he had written so many years, decades before India got its independence. But you can see all you can resonate and relate the articles, you know. So it's so you can also refer to that, the poem Where the Mind is Without Fear, if you have not read it. So it's a beautiful one. You can literally resonates with the Indian articles where it talks about equality, education, caste, racism. So just to add that.
This is basically about decolonizing education, where mind is without fear. And if you look at this Ekla Chalore, I think everyone must have heard of it, Tagore's lines. So that is also about decolonization. What he said was, if you read the whole context of Tagore, he was talking about setting up a school, that is Shanti Niketan. And his concept was how he came. He has discussed the philosophy of setting up Shanti Niketan. He said if the education department of the British government was not doing adequately for education, then we should walk the path alone and set up education for our children. So that concept is also about decolonizing. Yes.